Mupasiri. This is the Master of the High Court of South Africa. Case number 022498 of 2027.
My Lord, I appear for its flat, together with Mr. Kume, for the first respondent, the President, in these matters.
Yes, may it please the court, my Lord, I appear on behalf of the intervening party, SNM.
Oh, my Lord, my name is Tichaona Mupasiri. I'm a self-actor in the applicant in this application.
Yes, you are Mr. Mupasiri.
Yes, my Lord.
All right. When we call the matter, on Tuesday, there was also a Mr. Mawere who said he was involved in the matter and was in the hearing. I've seen there are application papers involving him. Mr. Mawere,
I have a medical paper for you. He had a blackout yesterday. So he's hospitalized right now. He's in hospital as we speak. Maybe you may need.
well, I'm just establishing if he's present or not. And you're telling me that he's not present.
Yeah.
Because all right, Mr. Mupasiri, you're intending to proceed.
Yeah.
Ready to proceed.
Yeah, I'm ready.
All right. Let's move then, and we'll deal with you. I propose to deal with in the following order. You are here as the applicant in this
Yes.
in the matter that's before me today.
Yes, my Lord.
And there is a first respondent and an intervening party. I will hear from you as the applicant, and then the first respondent, and then the intervening party, and then you will have an opportunity to answer anything you've heard in relation to the intervening application or the first respondent's submissions, and we'll deal with that after. So we'll start with you, and then I will deal with the first respondent and the intervening party. Is that Mr. Botman, that is how I propose to deal with that?
Yes.
Yes, that's it.
Thank you. Mr. Mupasiri. What are we here for? May I ask that question? What are you approaching the court for today?
My Lord, I'm approaching this court here today to hear, determine, and declare some constitutional disputes that have arisen based on the applications that have been put forward to court by both the purported intervening party and the first respondent, who is the President of South Africa. The reason why I'm saying he is the purported intervening party is because in his papers, he references, or the party references itself as the intervening party before it has been given leave or granted leave by this honorable court. And also, this purported intervening party ceased to be a company. I understand that in the court of law, one who needs to be given audience is a juristic person or a natural person. So this intervening party is as a result of the reconstruction law of Zimbabwe, which is inconsistent with Section 2 of the Constitution of South Africa. And it has to be tested in terms of Section 172, subsection 1 and subsection A by this honorable court to declare whether or not a Zimbabwean law has extraterritorial application in South Africa, whether a company which is controlled by the government of Zimbabwe, which is an organ of the government of Zimbabwe, has an audience or the court has jurisdiction to hear and grant audience to such a litigant. And also on the...
I hear you, Mr. Mupasiri. I'd like to just go back one step. This broadly, the issues you're raising were before this court last week.
Yes.
And an order was made by Justice Manuel.
Yes.
You're aware of that, and you've read the order.
Yeah, no, it was received by me through the email. I was absent. I was having exams in Zimbabwe from the 3rd to the 7th.
Yes, but you've read the order.
Yeah, I read the order.
And the order is very clear in what it says. You may and may not do in the interim while this case that appeared before Justice Manuel because it sets out a timetable and a method of filing affidavits and a time period for filing affidavits and so on. So I just want to hear from you from a practice and procedure point of view, procedurally. What is your application dealing with, other than the matters dealt with in Justice Manowan's judgment?
The application, my application, is dealing with the parties who are before this honorable court.
Yes, those are the same parties as in the
Yes.
Justice Manowan matter. It's under the same case number, if I'm not mistaken.
Yes. So what I'm saying is I want to clarify on why we have those parties so that you have a link of what I'm talking about.
Well, no, I want to be very particular about that order. That's an order of this court that was made, and it specifically deals with you personally in paragraph 4.2 of the order.
Yeah.
And it says that you're declared to be a vexatious litigant in paragraph 4.2.1, and 4.2.2 says you're prohibited from instituting proceedings in your own name, dealing with various parties, including those that you want to address me about now. And then it says that relief operates as an interim order pending a return date. So you have an opportunity to oppose and disagree with that order, if you choose to, by filing an answering affidavit and so on and so forth. So what I want to just hear from you first is, why is it not, on what basis are you approaching the court in direct contradiction to this order that was made last week?
My Lord, as you may be aware, I'm a layperson. I'm not a lawyer. But my understanding of Section 172, subsection 1, subsection A, it deals with the conduct and the law, and it gives jurisdiction to the court to hear, determine, and declare whether or not the conduct in issuing that particular order is consistent with the Constitution. It was not necessarily an attack on the judgment that was issued by Manowan J on the 6th. It was an issue, a constitutional question which arose after I read that particular judgment.
But you see, whatever view you take of the Constitution doesn't mean that you can ignore an order. I can't either. You can't ask me to ignore an order that was made by this court last week in relation to this matter. I can't ignore it. No constitutional provision allows me to ignore that order. If it's going to be challenged, it needs to be challenged properly. But this order sets out precisely the way in which procedurally you would be able to file affidavits opposing the order, and there is ordinarily, I haven't read whether it's expressly provided for, anticipating a return date if the return date is not too, it seems to be too far away. But so I think the real question, I understand you say you're not a lawyer, but the first question you need to deal with is whether I should not find that you are currently, in approaching the court, acting in direct contravention of this order.
Yeah, I get you, my Lord, on that, and I apologize for that. But I want to seek your indulgence, my Lord, that this order is in favor of that particular company, which is which is described as SMM Holdings Private Limited, a Zimbabwean company which was placed under reconstruction on the 6th of September 2004. And after the reconstruction, the setup of the company, the structure of the company altered from being controlled by shareholders who appoint directors to being controlled by a Minister of Justice who appointed the administrator who took the role of the directors. Then how this was done, I was going through the equivalent of that Reconstruction Act here in South Africa. I couldn't find anything. That reconstruction order was given on expert basis, where the minister, without any respondent, wrote an order to court to seek confirmation of the court. And it was confirmed in Zimbabwe as the law. And that law is the one that I'm saying, the one who is the beneficiary of that particular order, even the vexatious litigant order, and also the rudeness was given to a party who is not supposed to be given audience this court has no jurisdiction to recognize and hear anything from a party who was created from a law which is inconsistent with Section 2 of the Constitution of South Africa.
That is your primary submission, I've heard it.
Yeah.
Is there anything else? So you said, I asked you if you were not acting in direct contravention of last week's order.
Yeah.
And you said, well, if you are, you're sorry.
Yeah.
But it has further consequences. If you act in direct contravention of a court order, this court has supervisory powers to enforce its orders, and it must actually, otherwise this court's orders aren't worth anything. So what I do beyond hearing you say you're sorry, is it not a situation where I simply can't deal with this application because it's brought in contravention of the order that was made last week?
Yeah.
What I make of your conduct, if you're sorry, do you want to reconsider bringing this application and to withdraw it, or are you persisting with the application?
From what you have said, my Lord, I think I can bring the same arguments that I brought without knowing that I was going against the rules of the court, or I was acting in contempt of the court. I would like to bring that on a later date, but also I was asking for maybe the date to be pushed closer, because 20 January 2025 is too far. What is happening, the Constitution is under attack, and as a young person from Zimbabwe, knowing that many people are flocking to Zimbabwe, you know, Mr. Botma right here is being instructed by a law firm which was set up by the same guy who is being fought, who is Mtuma Mawere. We look up to these guys. When I was growing up, I wanted to be a lawyer, but I stopped being a lawyer because I could see what Mr. Manikai was doing. Mr. Manikai, Mr. Due, Mr. Wacha were given money.
I think you do need to focus on the issues that I have to decide, Mr. Mupasiri, because that may or may not be so.
Yeah.
If there is material that is relevant to the issues before the court, the appropriate way, and I appreciate you're not a lawyer, to deal with it is to put it into an affidavit, which is a sworn statement, and that will constitute evidence in an application, which is what this is, and that evidence can be considered by the court. And the order that was made last week gave you a period of time until 3 June, let me read it correctly. Paragraph 6 of the order says you may serve and file answering affidavits, if any, in response to the counter application of 3 June and the counter applications instituted by the President under another case number and case number 27 May by no later than 8 July. So you've been given until the 8th of July to prepare as detailed as you would like answering affidavits, to answer, to deal with the substance of the order that was made last week and all of the matters that you would like to address me on now. But that's what the order directs you to do. And I think that I'm yet to hear, and I'd like to hear from the President's Council and the Council for the intervening party what they say, of course. But I need to know from you whether, having raised with you the procedure set out in the order last week, you intend to persist with this application?
Not at the moment.
At the moment, you don't?
I won't. Maybe I will answer to the applications by 8th of July so that I comply with the rules of court.
You see, the risk that you run, I mean, you can say that now, and I'll need to hear from the other parties, because if you are in contempt of court, that has further consequences, quite serious consequences. And I'd like to say, what I'm hearing you say is that you would, as things currently stand, you would seek to withdraw this application, and you will put your all of your contentions into an affidavit that you will deliver by, can be delivered earlier, but by no later than the 8th of July. And any further provisions, if you want to anticipate the date, that is a process that you will have to deal with in those affidavits with proper cause shown, so that this court can consider whether there are good grounds to deal with the matter sooner than envisaged in the order that was made last week. But we have to run the matter on an orderly basis based on the orders of this court. Okay, thank you very much. I think let me hear from the Council for the President and for the intervening party.
Thank you, my Lord. I see the Court Order 21-63 is the missing page that you were referring to.
Well, I'm afraid I don't have, so in the hard bundle that was printed, I don't have 21-63,
63.
so let me see if I can access it on Cape Lines. Yes. I see the order in Cape Lines, 21-63.
That will have your paragraphs 3 and 4. And paragraph 4 is the rule NISA is issued calling upon Mawere and Mupasiri to show cause on 20th of January 2025. My final order should not be granted. And then it goes on declaring Mawere vexatious, and then you read 4.2, my lord, which was Mupasiri. My lord, Mr. Mawere was in court last week. He was present. The judge actually read out the court order. He didn't just upload it, he read it out. Emails were sent to both Mr. Mawere and Mupasiri and explained in detail what this court order said. My lord, the very next day, we were hit with another application, another urgent application. So to say that they weren't aware or they didn't know is incorrect. They were aware. They knew exactly what was taking place. It was explained to them in detail in court, and the next day an application was filed, and today another application was filed by Mr. Mupasiri. So, my lord, they know exactly what was happening.
Is that correct, Mr. Mupasiri? Another application was filed today?
Yeah, that's the application that I said I will include in my further submissions by no later than 8 July.
All right, sorry, thank you. I shouldn't have interrupted you.
No, my lord, that's fine. So, my lord, for contempt, we say we meet the elements. The court order was made. It is clear. The order was served. There was non-compliance within a day, 24 hours. They filed a different application. Willfulness and malafide. My lord, we were brought to court every week. We have had 44 applications. Every week, and none of these matters are resolved except the counter-application for vexatious litigation. When the matter is removed from the roll, another application is served and filed. If you look at case lines, there is a multitude of applications that are unresolved, except the contempt of court application. So, my lord, to say that they are unaware and they don't know what is happening is incorrect. This is willful and malafide. The President is asked to form a commission of inquiry to investigate judges and legal practitioners because they have ruled against them. Some of the judges have been cited because matters have been removed from the urgent court roll. A mere removal, and they are brought as respondents. And the President is being asked to do a commission of inquiry to investigate why that has been done. Although the President wasn't involved in 2004 when this Reconstruction Act came into play and the company was seized, it had no bearing in the matter at all. The only time they brought in is when they'd exhausted all avenues, went to the Constitutional Court, went to London, everywhere, and the matters were found against them. Then we are brought to court to say that we are now have to form a commission of inquiry. So, my lord, I submit that all the elements of contempt have been made. They were well aware. They were advised by the judge last week. He explained it to them. He read it out. Mr. Mawere actually informed the judge that he didn't need to be told what he can and can't do. He doesn't want to be told by anyone which affidavit he should file or not file. So they knew exactly what was going on.
So are you addressing me essentially in support of the notice of motion brought at page 32-132?
Yes, ma'am. Yes. The contempt.
Yes.
So we are saying they are in contempt of court. We have filed our papers, my lord, to show that that is the case. And we've attached the court order as well there to show that they knew that they couldn't bring this application, yet they have brought it in direct contrast to the court order given. Thank you.
Yes, may it please the court. My Lord, I need to very briefly just give your Lordship some background, and I'll be as brief as I can. My Lord, this matter starts out in 2004. There's the order taken before Judge van Oosten. It's a fraudulent order that's taken. Mr. Mawere is instrumental in it. There on the 6th of September, my Lord, there's the order that, or the decree in Zimbabwe. There's the reconstruction that's granted, my Lord. After that, my Lord, there are, I wouldn't say countless, my Lord, but there are 20 or 30 applications that are brought. In every single one of those applications, SMM's locus standi is accepted by this court. The issue is taken by Mr. Mawere, or there are reported judgments. SMM versus SAS in 2005 before His Lordship Mr. Justice Epstein, the matter before His Lordship Mr. Justice Willis, the 424, SMM versus Mawere. In both of those cases, my Lord, the point, this very same point, that this person, my Lord, Mr. Mupasiri, who has absolutely no locus standi in this court, zero locus standi, my Lord, the same point that he is now taking has been decided over and over and over. Lord, I have appeared for SMM for 20 years in every single one of those matters. Not once have we lost any issue or any matter. Not once, my Lord, has our locus standi not been accepted by this court. In every appearance before His Lordship Mr. Justice Pierce in December, my Lord, before His Lordship Mr. Justice Manoyam, every single judge, Judge Volley, Judge Webnath, every single judge accepts, my Lord, that we have locus standi, that we may appear and that we may have an interest. And despite that, my Lord, despite all of those cases, and Mr. Mupasiri says that he is a layman. Lord, he is a very intelligent man. He's well versed in the law. He brings these applications week after week. It's not for him to say, to now cower and say, no, but I'm a layman. When your Lordship puts to him, my Lord, that he may face jail time, which he should, my Lord, for what for his actions. So, my Lord, the background to this matter is, over a 20-year period, SMM's locus standi has always been accepted. The Reconstruction Act has always been accepted in this court. Yes.
Sorry to interrupt. I just want to make sure I understand what you bring an application. What application am I dealing with that you advance?
So we bring the counter application.
Intervene.
Yes, my Lord.
And what? Other than intervene, where is your? Where am I going to find your application for review today?
Yes, my Lord. My Lord. My Lord. Let me just firstly, and before I get to that, just tell your Lordship the draft order we are seeking, my Lord, and then I'll get to the application. So, my Lord, the draft order that we are seeking is at 21-71. So, my Lord, what we are asking for is that the application
3-1-68.
no, my Lord, 71. Yes, my Lord, starts at 71. So it is the so, Lord, that's the order that we seek. Lord, so the order that we seek is, of course, dismissing these applications, and then, my Lord, what we seek, and that's what I'll quickly address your Lordship on.
That's a revised order from the one that was in the bundle of documents provided, but I don't know if there's any material difference.
No, my Lord, there is not. It's mainly just
so it's been granted leave to intervene.
And it's the heading.
The applications.
Yes, my Lord. And then
to seek an order for
contempt, my Lord. And can I just very briefly tell you? So I'm 100% with respect in agreement with my learned friend, Miss Platt, my Lord. But we just put a bit of a spin on it in this sense, my Lord, saying that the order that was granted by His Lordship Mr. Justice Manoyam last week on Thursday, my Lord, that order stands. What Mr. Mupasiri has told you is that he was in willful default of that order. He knew of that order, he knew of it, and he says, no, he chose to write exams in Zimbabwe. He also pretends to be a South African, or he pretends to have an address here in Joburg, which I don't think, or I submit, I do not believe is correct. I believe he actually resides in Zimbabwe. But be that as it may, my lord, he was in willful default of that order. That order is granted. That order binds this court. That order stands. The Act is very specific, my lord, and as I read the Act, the Vexatious Proceedings Act, and I'm sure your lordship has it, but may I just hand it up to your lordship again, my lord? That's Act 3 of 56. As I understand the Act, and as I understand the position, my lord, the discretion lies, as it were, with Judge Manoya. But once the Vexatious Proceedings Act, once that order is granted and that order stands, as it does now, my lord, then it follows, your lordship will see on the second page, my lord, sub 4, so it is the Vexatious Proceedings Act, and it's section 2, then, my lord, sub 4 says, any person against whom an order has been made, and that is now Mr. Mupasiri and Mr. Mawere, who institutes any legal proceedings against any person in any court or any inferior court without the leave of that court, that shall be guilty of contempt of court. So, my lord, it's not, as I understand, it's not now, your lordship, it's not Peku 2, it's not the Zuma case where you, it follows now, my lord, that he shall be guilty of contempt of court, and be liable upon conviction to a fine not exceeding £100 or to imprisonment for a period not exceeding 6 months. And we make out the case, my lord. We have countless costs orders against Mawere. Well, Mr. Mawere, we have a 40 million rand claim against him, my lord. Mr. Mawere is an unrehabilitated insolvent. Mr. Mupasiri, as was indicated to your lordship, so brazen. Today, my lord, he launches, last night we received another application. And he says, my lord, he tells your lordship now, Mr. Mupasiri, in this court, now tells your lordship, no, he wants to do that later. No, my lord, he wants to do it today. Because I read from we received this, my lord, it was, it's an application for today. An interlocutory application in terms of section 172, so he brings it last night. It seems to have been filed like 4 minutes past 5 last night. It's then sent through, we get it last night, but he says, take notice that Tichaona Mupasiri intends to make application to this court at the hearing of this matter before His Honourable Justice Todd at 10 o'clock, or as soon as thereafter as counsel may be heard, seeking for an order in the following terms. So he brings another application again for today. It's not for later, it's for today. It's before your lordship, again today. That's what he does. He, Lord, despite the order that is granted against him, my lord, and Mr. Mawere, despite that, despite the warnings, despite all of that, they brazenly continue to be the worst contempt of this court and its orders. And my lord, I say this again with respect. I said it last week. In the 28 years that I've been at the bar, I've never seen this level of contempt for judges and for the court. And I'm sure my learned friend Ms. Platt, who's also a senior silk at this bar and who has practiced for a long time, will agree with me. It is the worst and the most brazen contempt that I have ever seen. And it would rank up there in South African legal history. And it's not good enough, my lord. It's not good enough to now for Mr. Mr. Mupasiri to say, well, no, well, I'm going to bring an application later, or, well, I might reconsider. The appropriate order, my lord, is the order we seek, as set out in the Vexatious Proceedings Act, and it is an order where Mr. Mupasiri is committed to incarceration for 6 months. It is the appropriate order, my lord, and it is the appropriate order for this court to make and to uphold the rule of law. those are the submissions, my lord, from our side. We say the draft order. We make out a clear case for the draft order. The act is clear in my submission. There might be I don't see the discretion, my lord, but if there is a discretion, the facts are before your lordship to exercise such discretion, and it's specifically where parties act like this, it is the appropriate order. We would seek the draft order as set out.
What you would presumably accept, Mr. Botman, is that I'll consider the question about whether there's discretion, whether or
Yes.
not I should find Mr. Mupasiri and Mr. Murray contempt of this court.
Yes.
There is a discretion as to what consequences would follow from that.
Yes.
And I hear you, but in other words, what sentence would be imposed for that contempt of court?
Yes.
There would be a discretion in that regard.
As your lordship please, my lord. Yes, the act says, my lord, says a fine not exceeding, and for a period not exceeding 6 months. Yes. My lord, as to that, I thought there would be some guidance from the Zuma case, my lord, which we will upload and just give your lordship the reference. My lord. The Zuma case deals with contempt and the appropriate sentence, but we'll upload that case and also provide it.
So the primary difference between what you are submitting to me now and what Ms. Pat submitted, or the draft order which the first respondent, the President, speaks, is that essentially is whether or not Mr. Mupasiri and Mr. Mawere should be given an opportunity from this point onwards to demonstrate compliance with the order by withdrawing all applications that have been brought in breach of the order,
Yes.
not proceeding with them, and that any further breach of that order would trigger imprisonment. If I understand Ms. Black's draft order, essentially that's it, and you're submitting to me that in the circumstances and in light of the seriousness of the breaches, that in fact that a sentence should be imposed immediately, irrespective of the potential.
Yes, my lord, with respect, yes, my lord. And my lord, what we just say, my lord, this is a case where they filed answering affidavits, my lord. There's an answering affidavit before your lordship. They have the opportunity, despite that, my lord. They still persist. And Mr. Mupasiri persisted. Well, he still persists. He still tells your lordship, no. I see my chances aren't good before your lordship, but I'm going to try it next week, or I'll try it somewhere down the line, my lord. That's where we say the difference comes in. But of course, it's in your lordship's discretion, my lord. And I'm not saying your lordship does not have that discretion, my lord. Yes, your lordship. As your lordship pleases.
Sorry, my lord, can I just mention our draft court order, paragraph 5 says if it's not withdrawn within 7 days, then we seek imprisonment. So it's similar, but we would allow them the opportunity to withdraw first. That's the slight difference.
Yes, I
yes.
think I did.
Yeah. Thank you, my lord.
Correct, I understood that. All right, thank you. Mr. Mupasiri, it's your opportunity then to reply on any of the issues that either counsel on the other side raised.
Oh, my lord, like I said, on the issue of contempt of court filing after the 6th, I'm sorry to the court for having done that, and would like to promise this honorable court that I'm going to make a withdrawal within 7 days as prescribed by the first respondent. And also just to highlight on what the representative for the first respondent has said with regards to the victories of the Reconstruction Act. I would want to take you to 2007 when one of the companies in Zambia, TAP Holdings, TAP was said to be an associate of SMM Holdings Private Limited, and the board was dissolved. When it was dissolved, Mr. Manikai, who is the instructing attorney, was appointed as the director. But in 2008, in the Supreme Court in Zambia, that judgment was turned down, it was rescinded, with the reason saying that no Zimbabwean law the Reconstruction Act is no extraterritorial application in Zambia. And in UK, like Mr. Botma said, in UK, they won all the cases in UK. In UK, government money was taken, $2 million was taken by AMG, who is the administrator of SMM under reconstruction, who is the one who is supposed to allow the SMM to sue or to be sued. It has to be with his leave that SMM has to be in court. They lost the case in UK. The UK courts refused to allow the Reconstruction Act to have extraterritorial application in the UK. So it is in Zambia and in UK where it was rejected. And also here
I think you can take it, Mr. Mupasiri, that I'm not going to decide those questions in this application today. And so I've heard Mr. Botma's submissions in that regard, but I don't need to take them further in dealing with the matters that are before me today here. And so what you're submitting to me now, I don't know whether it will be relevant or not in your answering papers, but that would be the proper place for you to raise any matters that you think are going to be relevant to this court deciding the main proceedings, if I can call it that, on the agenda. So you will have that opportunity. Anything else you want to address me on specifically regarding the contentions, the order that I've been asked to make? It's been submitted by the respective counsel I should make in regard to contempt of court.
Yeah, as submitted by the first respondent, I agree with that, and it's something that you would do without knowing the consequences. Like I said, I'm not a legal practitioner or someone who is a legally minded person.
I mean, there may be a distinction, Mr. Mupasiri, and you can tell me what the distinction is. You may have intended to act contrary to the order, which would make you in willful contempt, but not have known what the potential consequences of that are. Or you're submitting to me that you didn't realize that bringing these applications was in direct contradiction to the order that was made last time.
Yeah, it was not my realization that I was indirectly contravening the order that was given.
Indirectly, well, the proposition that's been submitted to me is that you were directly contravening, not indirectly, directly contravening the orders that were made last week.
Yeah, it was done out of unconsciousness. I didn't know how it would end up. I thought I was...
well, there's a distinction there. You didn't know how it was going to end up, meaning you intended to act contrary to the order because you didn't realize that there could be very serious consequences of doing so. Or you didn't realize what you were doing.
No, you schooled me today, my lord. So I learned from you. I learned from your direction, from guidance, and henceforth I'm going to stick by what you have said and what the first respondent has said is put in place before you.
Anything else you want me to take into account before I make an order?
Nah, I think that's all.
I'm going to make an order in this matter after my teacher, but I'm indebted to thank you, Mr. Mupasiri, for your submissions. Thank you to counsel for their submissions. I will deliver an order after the teacher, and so the matter then stands now. That's all. Which is normally for your benefit, around about 11:30. I had stood down, or I had invited parties to be present at 11:30, but in light of the possibility of dealing with matters more sooner than that, so you just see if the parties are present. Matter number 32 on the roll. 2024-061527 Vivian Club and Vincent Club.
As the court, please, my lord.
Yes.
In which confirming my appearance on behalf of the first and second applicant.
So the applicants, are the respondents present at the moment? It seems then that we will need to wait. I did stand this matter. I sort of scheduled it for 11:30, and I think that we'll need to deal with it then after teaching. I'll deal with it. I think there was an appearance of the respondent on Tuesday.
I'm made to understand so. And there is a
So I think
practice
we will in that case and call the matter at 11:30.
as the court pleases, madam.
Thank you. And then I had asked if there was a matter in which was enrolled yesterday, today, Fingerling. A matter of Fingerling and
As the court pleases, my lord, TM my email and I appear for the applicant in the matter.
yes.
My lord, I got a telephone call from counsel who will be appearing for the respondent in the matter. He asked me to ask the court to please stand the matter down until 2 o'clock.
Well, so let me just answer. There were answering papers delivered overnight, shall we say, as I understand it. Just a moment, let me find the papers on case 9.
As the court pleases.
Yes. So my difficulty.
Hey, my sister, you are saying you're having problems in uploading. Huh? Why shouldn't you join both tech? Why shouldn't you join both tech law? Both tech law.
Oh, I don't know what's that.
It's banking on Africa's future.
Oh, I have to answer this. Thank you.
Yeah?
I'm busy now.
You're busy. Okay.
check all your letters together and sit down with you and get things done. If they are honest, then it's a good.
Of saying that's the court of last instance. So all these courts, like high courts, they have jurisdiction to entertain constitutional questions without having to go to the apex court. So that was the issue that I was.
But I think the best way is to approach it and indicate to them that this is a constitutional issue. I think it will be, you know,
because I've been like in Zimbabwe, they used to say the president has immunity, but our new constitution, section 167, subsection 2, subsection D, it says the president can be taken to court based on his conduct is the president or the parliament, that section. And only the constitutional court has jurisdiction to hear, determine and declare whatever that will be. So I took the president to court in 2021 on the same matter after, it was before I treated him, because I wanted to hear his version on whether or not he was involved in that. Because his lawyer, the one who is the briefing of everybody, is the one who is controlling the judges, controlling the legal system in Zimbabwe. Everything you find him everywhere.
Yeah, but that you should just get a lawyer.
Yeah. Are you interested in being that lawyer? Are you interested in being that? Because I may try to scout with the lawyers ready before me.
No,
Oh, all right.
they are
Okay, all right. Oh, yeah, enough.
no, you can talk to them. I'm the High Court matters.
Yeah, all right.
You can sit down and talk to them. They are not, I don't think that they'll need millions of dollars. They will need just something to work on.
See, so you see, sometimes poverty is the one that leads us to.
Those who might have interest.
Especially in Zimbabwe, they don't want even the free lawyers. They've seen a lot in terms of these litigations that involve
Because
politicians.
I think if it goes to the constitutional court, because if it has to go to the constitutional court, you will have to have, let's say, 2 or 3 applicants. You will have to have at least 2 or 3
Yeah.
advocates who exist. But with the preliminary issues, different cases,
Yeah.
I think you can sit down with them and see what can be done.
Recall matter number 29, case number 2024-02248. Said I would make an order in the matter. And I'm going to make that order. Moment. I make the following order. 1. SLM Holdings Private Limited is granted leave to intervene in applications filed under the above case number dated 5 June 2024, 7 June 2024, 11 June 2024, 12 June 2024 as the sixth respondent. Paragraph 2, application filed under the above case number dated 5 June 2024 is dismissed. 3, the application filed under the above case number dated 6 June 2024 is dismissed. 4, the application filed under the above case number dated 11 June 2024 is dismissed. 5, the application filed under the above case number dated 12 June 2024 is dismissed. Paragraph 6. It is declared that Mutumwa Ziva Mawere is guilty of the crime of contempt of court, for instituting proceedings in breach of the court order granted by His Lordship Mr. Justice Manavan and the above case number on 6 June 2024. Paragraph 7. Mutumwa Ziva Mawere is sentenced to imprisonment for a period of 6 months. Paragraph 8. The sentence paragraph 7 is suspended on condition that Mr. Mutumwa Ziva Mawere takes no further step in breach of that court order. Paragraph, I believe it's paragraph 9. It is declared that Tichaona Mupasiri is guilty of the crime of contempt of court for instituting proceedings in breach of the court order granted by His Lordship Mr. Justice Manavan under the above case number on 6 June 2024. Paragraph 10. Tichaona Mupasiri sentenced to imprisonment for a period of 6 months. Paragraph 11. Sentence of Mr. Mupasiri is suspended on condition that he takes no further step in breach of that court order. Mutumwa Ziva Mawere is ordered to pay the costs extension application. And the application is dated 5 June 2024 to 7 June 2024 on the attorney and client scale, including the cost relating to agency and senior counsel's fees of scale C. Paragraph, Mr. Mupasiri is ordered to pay the costs of the six respondents in the intervention application dated 11 June 2024, 12 June 2024 on the attorney and client scale, including the costs relating to agency and senior counsel's fees on scale C. Paragraph, Mr. Mawere is ordered to pay the costs of the first respondent. The application was dated 5 June 2024, 7 June 2024 on the attorney and client scale. Paragraph, Mr. Mupasiri is ordered to pay the cost of the first respondent. The application was dated 11 June 2024, 12 June 2024 on the attorney and client scale.
That's your
As the court pleases.
I now call matter we were dealing with just before a tea adjournment is I'd like to leave with Ms. Simani, case number 1-57918, and that is put out on Thursday last week.
As the court
Evans Tichaona versus Community.
As the court please.
Come up, then just we have perhaps understand, yeah, I think that's the easiest. Right, Ms. Simani, you
Oh, yeah. Yeah, no, that's it.
Comes with the territory.
Yeah. Yeah. I don't do that. The idea is, you know what happens? The most important thing is to write history. People will judge us for not acting. Right?
Who's going to fight for you?
Right now, the Zimbabweans are coming to South Africa. It's because those guys are criminals in Zimbabwe. Big time. That you see, the lawyer who is instructing these guys. That lawyer, his law firm was set up by three guys.
Hey, how are you?
You're done with your message?
Yeah.
So they didn't decide to.
No, this is a constitutional issue.
Yeah.
They cannot do that.
Yeah.
Because what is happening is it's misunderstood.
Yeah.
And these guys have been lying from way back. When it happened, I was 22. I had no means and I had no knowledge of what was happening. In Zimbabwe, there was a law which was created by the now president of Zimbabwe, which is the Reconstruction Act, Reconstruction of State-Indebted and Solvent Companies Act.
Yeah.
What it was saying there are companies which are indebted to the state. But what is a state? A state in Zimbabwe can't be in a contract. So if you have ESCOM is a juristic entity. It's a company, but the main shareholder is the government. So as a company, it has the right to sue and to be sued. It has the right to collect what is owed to it or to pay what it owes. So now the government came in to say, now I'm ESCOM. You understand? Using public power, they use public power to utilize that public power and take someone's company without compensation. So they took Mawe's company. They lied to Mugabe. Mugabe agreed because Mugabe said, these are my employees, they are telling the truth. In 2009, Mawe was dissatisfied following a report that was done by the unit government, the inquiry that was done, headed by the Minister of Home Affairs. So he was specified in Zimbabwe, but he was dissatisfied because of that report.
But why don't you get an attorney here?
What happens now?
No, listen to this. Unfortunately, let's look at it from any man's perspective. Let's look at the court. The acting judge who's seated cannot ignore two senior counsels that are sitting. Understand? Did you hear him saying I've been in the bar for 28 years? And now he's actually the one that has been. So the best thing that you can do for yourself is to get someone who can advise you. Even if it's a junior situation, junior person, at least let them advance what you are doing. You understand? Without anything else, if it's a constitutional matter, it's a constitutional matter. All these other ones don't make sense. And the constitution is just the But the most junior of guys can even argue the constitutional matters against the senior guys. You understand? It doesn't change the fact.
Yeah, I understand. You know the problem that is. We are not always even the president. The reason why this was cited was drawn. It was as a result of an application that was made. I work for an organization. That organization is Justice and the Rule of Law. It says anything that happens to you can happen to you tomorrow. So if you allow that to keep on happening,
It's an injustice.
yeah, it's an injustice. So we are saying now we are having stuff in this Soviet country. Then we have Zimbabwe. Zimbabwe has its own laws, which are valid in Zimbabwe. You see, despite the issues that we have with that reconstruction law, you see. But how did this law cross the border?
Become valid
in South Africa.
That's the reason why.
When we have to find the equivalence of that law in South Africa, whether it's judicial management, whether it's the business rescue, whether it's insolvency,
You understand? Look at so you can even raise that because they have now classified you as a vexatious litigant, meaning even that argument doesn't stand.
But now you see, the constitution is Can I take your number?
Oh, take mine and my attorney's number.
How are you? Okay. What's your...
Advocate Nzimane, right?
Just this advocate
Nzimane.
Nzimane.
And 060 301 34 96.
Then for the
For
attorney,
Mr. Mutamai.
Mr. Mutsamai, you will be going where? Mutsamai is going, huh?
Yeah.
Okay. Mutsamai. I once stayed in Botswana.
Mutamai.
The Walker, yeah. Johnny Walker. Mr. Mutsamai. The number? 081 047 78
Again,
0810478. Okay, so it's 081 047 Okay, 7878.
Fashionista.
No, thank you. My name is Mupasiri. I'll send you a message on WhatsApp.
No, thank you.
And say your number. Nice meeting you.
If you have.
I learned a lot from you.
No, maybe you will have as your counsel because all these other issues.
You will be welcome in Zimbabwe, not what happened to Dalimpo. When he came there, he was told you can't practice because they wanted to steal the election.
Oh my God.
Yeah. So I'm just praying that we have more time.
Yeah.
But,
I can be there for the answer before the 8th of July.
And that's my birthday.
Oh, is it?
I'll be turning 43.
You must make sure.
Yeah, no, I'll be around. Yeah.